Hello, my name is Kathryn Walker. I serve as City Attorney for the City of Norman, and I'm also a member of the Oklahoma Association of Municipal Attorneys, the OAMA for short. One of the missions of the OAMA is to provide those practicing municipal law across the state of Oklahoma with resources to assist in providing sound advice to the cities and towns they represent. OAMA has established a program that provides such information accessible through the OAMA website, www.okmunicipalattorneys.org. This session is to discuss municipal ethics for city attorneys. We're going to talk about what does a municipal attorney do, what are the rules of engagement we must follow, and communication with the client. So what does a municipal attorney do? Municipal attorneys serve as the chief legal officer of the city. They provide legal advice, they work to minimize the city's liability, and they promote compliance with the law. The job function of a municipal attorney does not change with the hiring structure, whether it's city council or city manager, but the dynamics certainly can, and we'll talk a little bit about that. So what does a municipal attorney do? As you can see, municipal attorneys operate in a number of areas of the law, and it's really challenging to become an expert in all of these areas, but we are charged with the duty to provide competent representation. And so taking advantage of training opportunities, your colleagues in municipal law, and other opportunities for engaging specialists is really important. This is from a study done a couple of years ago by Thomson Reuters, and it really highlights the challenges facing government attorneys. You have more complex issues with less resources, a higher workload, more diverse matters, 24/7 access through email, text, and a cell phone with the expectation of an immediate response. Oftentimes we face the challenge of this perception that government attorneys are somehow less qualified, critics who speak louder have more credibility, and we're seeing in the field an increasing turnover because sometimes the work-life balance that is typically the benefit of a government practice does not exist in municipal practice. So I want to talk to you about the rules of engagement, and these are, of course, the rules of professional responsibility. I'm going to highlight a few that really impact the practice of the municipal attorney. So first, of course, is who is the client? This is the fundamental question that I come back to over and over. Is it the city manager? Is it the mayor? Is it council members? Or is it city staff? And does this change depending on who employs you? We'll talk about each of these things. So the rule here is Rule 1.13, organization as the client. And what that rule says is that an attorney employed or retained by an organization represents the organization through its duly authorized constituents. So who are the duly authorized constituents of a city? It can be the officers, those elected officials, the trustees of your public trust, and the employees. In dealing with the duly authorized constituent, the lawyer has to explain the identity of the client when the lawyer knows, or reasonably should know rather, that the organization's interests are adverse to those of the constituents with whom the lawyer is dealing. So oftentimes in municipal practice, your duly authorized constituents may not agree. Maybe the staff wants to do something different than the elected officials. The city manager wants to go in a different direction from the city council. And so those are issues that we have to work through as they come up. So how do you resolve those conflicts between duly authorized constituents? Well, it depends on the type of matter. If it's a policy or legislative matter that's in the purview of the city council or the board, you want to honor those actions that that body has taken as a collective. Then you want to work with your CEO. And of course, this may be different depending on the type of government. In a strong mayor and aldermanic form of government, it's going to be the mayor who's running the day-to-day operations. Council manager form of government, it's the city manager. You want to work with that person who's managing those day-to-day operations, but you still want to honor the direction and the actions of the collective council. And then, of course, staff. If it's an issue where the organization's interests may be or become adverse to one or more of its constituents, the comment to the rule here talks about how the lawyer needs to advise that duly authorized constituent that they cannot represent them and that they may need independent counsel. Care must be taken to assure that the individual understands that when there is such adversity of interest, the lawyer for the organization cannot provide legal representation for that constituent, and discussions may not be privileged. And I'll give you an example here. In Norman, we dealt with recall challenges. We had a number of petitions circulating for council members to be recalled, and council members were coming to me, subjects of the recall, wanting advice on how to challenge those petitions. I had to have this conversation. I cannot represent you. My job is to represent what's been authorized and adopted by the city, which is the charter provisions authorizing the recall. And so my role in that situation was to represent the city as an organization, not each individual council member. And so we had to have that conversation. And again, that communication was really important under this rule. Competent representation is, of course, one of the most important rules for any practicing attorney. It's easy to say everyone deserves competent representation, but what does that mean in a municipal practice where you work in so many areas of the law? Competent representation requires the legal knowledge, skill, thoroughness, and preparation reasonably necessary for the representation. So this is where the training is important. You've got to continue to grow your skills, continue to take advantage of training opportunities, and prepare for your meetings so that you can be reasonably ready to provide that competent representation. Rule 1.2 deals with the scope of representation. The lawyer shall abide by a client's decisions concerning objectives of representation and must consult with the client as to the means by which they are to be pursued. The lawyer may take such action on behalf of the client as is impliedly authorized to carry out the representation, and the lawyer shall abide by a client's decision whether to settle a matter. Again, this comes down to what the issue is that you're dealing with. If it's an issue that's in the purview of counsel, you're going to want to communicate with counsel and get direction from the majority of counsel on what to do in a case. If it's an employee issue or something where it's within the city manager's purview, you're going to want to have those discussions with the city manager to talk about how the representation should occur, how it should go, and what the client wants you to do. The lawyer shall not counsel a client to engage or assist a client in conduct that we know is criminal or fraudulent, but we can certainly discuss the legal consequences of such conduct. And again, that goes to communication and being straightforward with your client so they know exactly what the consequences of any proposed actions are. In our role as municipal attorneys, we often take on the role of advisor, and this is covered by the rules of professional conduct as well. Rule 2.1 says, in representing a client, a lawyer shall exercise independent professional judgment and render candid advice. In rendering that advice, you may not only refer to the law, but to other considerations such as moral, economic, social, and political factors that may be relevant to the client's situation. Oftentimes, we don't want to get involved in the middle of the politics, but there are very real consequences to actions your client may propose. And under this rule, you have an obligation to give them candid advice about those things. The client is entitled to straightforward advice, and the attorney should not be deterred from giving candid advice by the prospect that the advice will be unpalatable to the client. That's a tough one. You know they don't want to hear it. It's not going to be the result they want, but you are obligated to give that straightforward advice. In general, a lawyer is not expected to give advice unless they're asked by the client. However, when you know that your client is proposing a course of action that's likely to result in substantial adverse legal consequences, you have a duty to give that advice regardless of whether they ask for it. A lot of times this happens in our representation of public officials. I think they sometimes don't ask for advice because they know it's not going to be what they want to hear. You have a duty to provide it if you know that what they're proposing could result in substantial adverse legal consequences to your city. Rule 3.1 says a lawyer shall not bring or defend a proceeding or assert or controvert an issue therein unless there is a basis in law and fact for doing so that is not frivolous, which includes a good faith argument for an extension, modification, or reversal of existing law. Comment 1 to Rule 3.1 highlights the duty to use the legal procedure for the fullest benefit of your client's cause, but it also notes that you have a duty not to abuse legal procedure. Comment 2, I think, is really helpful in most situations that you might deal with. It isn't necessarily a frivolous case just because you don't have all the facts yet. Inform yourself about the facts of the client's case and the applicable law and to determine if you can make good faith arguments in support of your client's position. Even if you think your client's going to lose, if you have good faith arguments, it's not a frivolous lawsuit. So the next thing I wanted to talk about was communication. You can see the importance of communication highlighted through all of the rules, really. But I wanted to talk specifically about Rule 1.4 and then other rules pertaining to communications with your client. Rule 1.4 says, lawyers shall promptly inform the client of any decision or circumstance that requires the client's informed consent. You must reasonably consult with the client about the means by which the client's objectives are to be accomplished. Keep the client reasonably informed about the status of the matter. Promptly comply with reasonable requests for information. And consult with the client about any relevant limitation on your conduct when the client expects assistance that you cannot provide under the rules. You must explain a matter to the extent reasonably necessary to permit the client to make informed decisions regarding the representation. The important thing is here, the client should have sufficient information to participate intelligently in decisions concerning the objectives of the representation, and that requires frequent communication. It also comes back to the question of who the client is. Again, you're not going to go to your council with information about day-to-day operations of the city in most forms of government. You're going to go to your city manager, your mayor, whoever is running those day-to-day operations. In this council manager form of government, I would not go to the council and inform them about employee discipline issues because that's within the purview of the city manager. I will go talk to the city manager frequently about those things because he's the person that needs to be informed. And so communication is really important, and again, knowing the identity of the client. We get asked a lot about which of our communications with our client are privileged and which are subject to the Open Records Act or other disclosures, and so I wanted to talk a little bit about that. The rules of professional conduct do address confidentiality of information in Rule 1.6. It says, the lawyer shall not reveal information relating to the representation of a client unless the client gives informed consent. The disclosure is impliedly authorized in order to carry out the representation, or specific circumstances apply, such as disclosure being necessary to prevent reasonably certain death or bodily harm, etc. It's a pretty unusual exception or circumstance when this rule does not apply. Comment 4A to this rule deals with government lawyers specifically. The requirement of maintaining confidentiality of information relating to representation applies to government lawyers who may disagree with the policy goals that their representation is designed to advance. Even if you don't agree with what your client wants to do, you have to maintain the confidentiality of that information. There are also other areas in the law, of course, that protect client-lawyer confidentiality, and that includes attorney-client privilege, work product doctrine, and I wanted to talk about those a little bit, but first let's talk about the Open Meeting Act and the Open Records Act. The Open Meeting Act allows executive sessions, so closed sessions, only in certain circumstances. When it's talking about confidential communications between a public body and its attorney, those situations are limited to conversations about pending investigations, claims, or actions if the public body, with the advice of its attorney, determines that disclosure will seriously impair the ability of the public body to process the claim or conduct the investigation, litigation, or proceeding in the public interest. The Open Records Act does not apply to records protected by the attorney-client privilege and the work product immunity from discovery. As we know, almost everything related to the city could be considered a record, so it's important to know how the rules of professional conduct apply to attorney-client privilege and how the Open Records Act deals with those things. Is it privileged? This comes up in a couple of different circumstances, this question of does the attorney-client privilege apply? Does the work product privilege apply? And they're really arising out of the evidence code and the discovery code. So these are more dealing with requests for information in a litigation context. Is it privileged under the evidence code? A communication is confidential if it is not intended to be disclosed to third persons other than those to whom disclosure is made in furtherance of the rendition of professional legal services to the client or to those reasonably necessary for the transmission of the communication. In those circumstances, it could be protected in the context of litigation under 12 OS Section 2502. The client holds the privilege, so again, remember who the client is. If it's your public body, one of them cannot waive the privilege. It needs to be an action of the public body. Communication between a public officer and its attorney, however, is not privileged unless the communication concerns a pending investigation, claim, or action, and the court determines the disclosure will seriously impair the ability of the public officer to process the claim or conduct a pending investigation, litigation, or proceeding in the public interest. You can see how that language mirrors what is in the Open Meeting Act. Same type of language that would permit you to go into an executive session is the same information that's protected from disclosure under 12 OS Section 2502. Is it protected from discovery as work product? And this is in the discovery code, of course. There it says documents and tangible things prepared in anticipation of litigation or for trial or for another party or its representative are not discoverable. So anything that you're working on that's in preparation for something you think might be litigated or for trial or for another party is not discoverable. And so that's an important thing to keep in mind as well. That privilege is claimed by the attorney, not the client. So you know what your work product is, and you would be tasked with describing that to a court potentially to protect that information. In summary, there's several principles here that you need to keep in mind at all times. Be cognizant of the identity of your client in any given situation. Know whether the information you're providing is something where the city manager needs to take the lead as the client or the counsel or the staff. Work ahead, spot the issues, and develop your competency. It's really important to know ahead of your council meetings especially what issues might come up so that you can look into those issues and be prepared to answer those questions. Going to ongoing trainings and participating in things like this program are good ways to develop your competency to ensure competent representation. Don't ever be afraid to say, I don't know. I don't know is much better than making up an answer. And don't be afraid to lean on subject matter experts when you need them. For me personally, I know if I get a bond question, I want my bond counsel there to answer it. They have that expertise and I don't. And that is part of being a competent representative, is knowing when you need to lean on someone else for the answer. Finally, communicate early and communicate often. Your client should always be up to date on the issues that pertain to them and that affect their representation. And that communication is really important both to meet your obligations under the rules of professional conduct, but to continue to develop working relationships with your client. Again, my name is Kathryn Walker. I serve as a city attorney for the City of Norman, and I'm also a member of the Oklahoma Association of Municipal Attorneys. OAMA has established this program to provide municipal law information, which is accessible through the OAMA website, www.okmunicipalattorneys.org. Listed there on that website are the names and contact information of OAMA board members, partner organizations such as OML, the Oklahoma Municipal League, and the Oklahoma Municipal Assurance Group, OMAG. If you're a municipal law practitioner, please take advantage of these resources, and you are certainly invited to consider an OAMA membership. We hope you'll join us.